Mr. Burrell, BFAA filed another lawsuit in July 2015 last month. Can you please explain to us what that lawsuit is about and also how it affects the other lawsuits that were filed by BFAA several years ago?
Yes, on July the 13th of this year, 2015, the Black Farmers and Agriculturalists Association, through our attorneys, filed a complaint in the Federal District Court for the District of Columbia, Washington, D.C. And that complaint is against the United States Department of Agriculture as a prime contractor, giving monies or paying funds to a subcontractor in Portland, Oregon, which we refer to as the claims administrator. The claims administrator is a corporation that regularly gets involved with class action litigations, and its name is Epic Systems Incorporated. Epic Systems is receiving taxpayer funds via the United States Department of Agriculture. As such, to the extent that Epic, or the claims administrator, is discriminating against African American males in one of these lawsuits, the lawsuit is styled the Hispanic and Female Farmers and Ranchers Voluntary Claims Process, which is the latter lawsuit. Remember, we had Pickford 1, and then we had Henry Black Farmers Discrimination Litigation, the second lawsuit. The third lawsuit was Keepsigle versus Vilsack. Keepsigle is a group of Native Americans. Now, the Garcia lawsuit and the Love lawsuit, which would be for Hispanics and women farmers and ranchers, is the lawsuit that we filed a motion to intervene in 2013. We talked about the motion to intervene, how we want our members to be a part of and get into that lawsuit. Well, that settlement or that issue or controversy is still in court. However, to the extent, again, that African American males and or individuals filing on their behalf, whether they are alive or deceased, were discriminated against under a statute that Congress passed in 1964. It is called the Civil Rights Act of 1964, particularly Title VI of that act. Now, that act was started by President Kennedy in 1962, and we know he was killed in 63. However, President Johnson and Dr. Martin Luther King and others were able to get Congress to pass the Civil Rights Act of 1964. Title VI says that any government agency or any individual, firm, corporation, or whatsoever receiving taxpayer funds cannot and will not be allowed to discriminate against an individual based on their race, their gender, their sex, or their national origin.
Defendant actions have violated Title VI of the Civil Rights Act of 1964 as codified under 42 U.S.C. Section 2000D. Prohibition against exclusion from participation in, denial of benefits of, and discrimination under federally assisted programs on grounds of race, color, or national origin states. No person in the United States shall, on the grounds of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subject to discrimination under any program or activity receiving federal financial assistance.
We are saying that to the extent that the claims administrator is sending out letters and has been sending out letters since July of 2013, stating that, among other things, if you are a black male or an African American male, you cannot participate in this lawsuit.
Dear claimant, Thank you for your interest in the Hispanic and women farmers and ranchers claims resolution process. To participate in this process, you must be either Hispanic, Latino, or female. On your claim form, you indicated that you are an African American male. As such, you are not eligible to participate in this claims process, and your claim has been denied.
That is a violation of a horrific act. Not since 1942, when this country made a decision to intern or to isolate or quarantine Japanese citizens at the start of the World War II when Japan bombed Pearl Harbor. This country, after reviewing that law, after reviewing that statute in 1942, took a pledge and stated that never again will the government be allowed to discriminate against any citizen of this country on the basis of race, ethnicity, national origin, or gender. We believe that what the claims administrator is doing is a direct and patent violation of that statute. So that's why we are filing suit against the Department of Agriculture and the claims administrator. How does this lawsuit, your second question, how does this lawsuit then impact what we've already done? We hope that it's a favorable impact, because sometimes the judges, the courts, when you allege that someone is doing something wrong, they may not agree with you. In other words, they may say, well, there is no real covert or overt act on the part of the perpetrator. But when you find out, as the old saying goes, now it's walking like a duck, and now it's talking like a duck or quacking like a duck, the courts then are more apt to go back and revisit your original complaint. In other words, there was a smoking gun, there was smoke, and now we are maintaining that here is the fire. This is prima facie evidence. This is irrefutable evidence that these agencies, that Tom Vilsack, and as the Secretary of Agriculture, he has hired these subcontractors to adjudicate, facilitate, and shall we say, oversee these lawsuits. But these individuals are violating Title VI of the Civil Rights Act of 1964, and that's why we're suing them. And that's the purpose of this latter lawsuit. We're hoping now, as I said, this will give the Supreme Court or a reviewing court more ammunition to prove the allegations and the other charges that we made against the USDA all along.
Hasn't BFAA released a press release stating that it will be demonstrating in front of the court in Washington, D.C.? Isn't this the very court that you're asking to review the motion to intervene that you filed against the USDA and the claims administrator?
Yes, this is the exact same court. We have issued a press release stating, among other things, that the 3 federal judges who have been adjudicating the various lawsuits that we described earlier, the Honorable Paul L. Friedman has been adjudicating and has jurisdiction over the 2 black lawsuits, Pickford 1 or Henry Black Farmers, sometimes referred to as Pickford 2. Judge Emmett Sullivan has been adjudicating the claims in the Keepsiegel versus Vilsack, which is the Native American lawsuit. A 3rd federal judge in that same court is the Honorable Reggie B. Walton. Judge Friedman, Judge Sullivan, and Judge Walton, we maintain, have allowed and should not have allowed the Department of Agriculture to pay a subcontractor, EPIC, which is the claims administration. In our opinion, these federal judges have looked the other way. They're winking at wrongdoing. These judges have been sworn to uphold the Constitution. Federal judges are the guardians of the Constitution. And we maintain that these judges, tacitly or otherwise, subtly or otherwise, are agreeing with what is otherwise, as we just said, a path, a nightmare, a horror that this country has sworn that it will never allow any citizen of the United States to be the victim of race discrimination from at least a government agency. We know that some private actors, colleges, universities, restaurants, hotels, state actors, and private actors have, since 1942, tried to separate individuals on the basis of race and sex and gender. But the federal government of all agencies abhors and should be ready and watchful to make sure that no agency, whether federal or otherwise, will revisit this or orbit back to this nightmare that we talked about in 1942, when this country interred Japanese Americans. Quarantining black farmers is the exact same thing that they are doing, that they did do in 1942. And that is, they are violating a federal statute that says you should not have a lawful proceeding wherein you segregate individuals. You have a bus for black farmers, a water fountain for white farmers, and shall we say another school, as it were, for Native Americans. Those three judges should not have allowed the government to separate individuals by race, sex, or national origin, let alone quarantine or deny a group of plaintiffs, i.e. black farmers. Keep in mind, black farmers were the ones that started the lawsuit in 1997. They started this lawsuit. They were the ones that went to court in August of 1997. But for their action, none of these other groups would be allowed to receive any relief or redress in the first place. Now you're going to let two of these groups, the Hispanic component and the female component, file a lawsuit and tell them that you will not, or tell black farmers who were not able to get into Pickford 1, who were not able to get into Pickford 2, and who were not able to get into Keepsigo. You're going to tell those individuals, we're going to have a lawsuit, we're going to have a lawful proceedings, but you can't become a party because of your race. You're an African American male. That is as egregious. That's foreboding. That is frightening. Every African American in this country should be concerned. Your second question is, yes, we have released a press release where we will be demonstrating peaceably outside of the federal courthouse where these three judges reside. We're asking every member to participate, to join us on September the 21st, Monday, September the 21st at 10 a.m. in front of the Federal District Court for the District of Columbia. The address is 333 Constitution Avenue. We're asking all African Americans. Black farmers matter as well. This country is allowing police states, police departments, prosecutors, attorney generals to openly violate the constitutional rights of black males, whether you are a black man on a farm or a black man in Ferguson. Now, we know that other groups are going to be marching in Washington or to Washington, celebrating the 50th anniversary of the Voting Rights Act of 1950. However, many of the African American leaders and many in the African American civil rights community said absolutely nothing when these three judges allowed a federal agency, the Secretary of Agriculture, representing the Department of Agriculture, to hire the adjudicators, the arbitrators, the lawyers, and allow those individuals to openly violate the civil rights of African American males on the one hand, and yet are marching to say, and we're not anti-marching for the Voting Rights Act of 1965. But if you're going to memorialize the Voting Rights Act because it was passed 50 years ago, you have thousands of black men or thousands of black women who are filing on behalf of black men their brothers, their uncles, their fathers, their grandfathers. We have a bird in the hand violation here. The 1964 Civil Rights Act is being violated openly, and these judges are allowing it. We maintain that they are knowingly and willingly looking the other way for all intents and purposes. And yes, you're right. These are the same, whether this is the same court, rather, where we file all of our motions. Reason being is when Congress created the legislation in 1998, in October of 1998, authorizing the Treasury Department to pay $50,000 checks and other checks to victims of racial discrimination. As I said, the black farmers filed that lawsuit. Congress said that the Federal District Court for the District of Columbia would have original jurisdiction. Therefore, any matter, any controversy, any victim who believe that they have sustained injury as a result of the actions of the Secretary of Agriculture will have to file their motions in that same court. We are hoping, though, that these three judges will recuse themselves. We're going to ask them to recuse themselves. We believe that Judge Freeman, Judge Sullivan, and Judge Walton should not hear, and we believe it is a manifest conflict of interest for those three judges at least to hear a lawsuit that is implicating them as not upholding the Constitution as it relates to the rights, immunities, and privileges of African American males.
Mr. Burrell, you said the Voting Rights Act of 1950. Did you mean the Voting Rights Act of 1965?
Yes, indeed. Thank you for that note. The Voting Rights of 1965 is the act that I was referring to. What we're saying, there were two acts passed in almost as many years, for that matter. But in 1964, President Johnson and Dr. Martin Luther King and others were able to get Congress to pass the Civil Rights Act of 1964 and its pertinent part, Title VI, which is what we are saying that Mr. Vilsack and the Claims Administrator is violating now. The Voting Rights Act of 1965 was passed a year later as a result of certain civil rights leaders trying to cross the Edmund Pettus Bridge on their way from Selma to Montgomery, Alabama. And subsequently, a couple of months later at least, Presidents Johnson and others were able to get Congress to pass the Voting Rights Act of 1965. Now, what we're saying is, we know that some other civil rights leaders, the NAACP, the Black Caucus, and others, are celebrating the 50-year passage of the Voting Rights Act of 1965. And they're going to be marching from Selma to Washington. What we're simply saying is, it's fine to memorialize an act, but the Voting Rights Act should be memorialized. But no one is saying anything about USDA violating the Civil Rights Act of 1964. Here in 1964, you have thousands and tens of thousands of African American males and others who stand to gain billions of dollars, but for the fact that the Claims Administrator, Tom Vilsack, the Secretary of Agriculture, and others are allowing that law to be violated. So we have a bird in the hand statute, the Civil Rights Act of 1964 being violated. No one is saying a thing. There are more individuals who would be impacted by that, financially speaking. It's not a matter of do you have one act or the other. Well, we believe it's a little bit hypocritical, as it were, to say we're going to memorialize one act and do nothing when the government violates clearly, manifestly, another Civil Rights Act for which we believe is just as important.
Are you saying that the three judges deliberately allowed the lawyers to discriminate against black farmers?
We're not saying that they deliberately allowed the lawyers and or the parties to include Mr. Vilsack and or the claims administrator to discriminate against black farmers. Here's what we do know, is that those agencies are discriminating against black farmers. It is crystal clear that Title VI is indeed being violated. Title VI is explicit. The plain language of that statute states that, among other things, no government agency can subject a citizen of the United States to the exclusion of a process based on race, ethnicity, or their natural origin or gender. That much we know. To the extent that those letters that the claims administrator is sending out to African Americans makes it perfectly and crystal clear that those individuals are denied for one reason and one reason only, the color of their skin. And that here again, this is a brazen and frightening violation of that act. Now, whether the judges deliberately allowed it is subject to, as we say, congressional investigation, because that's what we're asking Congress to do. We're asking the Judiciary Committee on the Constitution of Congress, both houses, the Senate and the House of Representatives, to look at the behavior of all of these parties. One of the things that we know is that there is a plethora, there is a superabundance of case law where the Supreme Court has said, among other things, and let me just read you one of the paragraphs that our attorneys cited to these judges. They said that distinctions between citizens based solely on their ancestry are by their very nature odious to a free people. The Supreme Court has gone on to say in other cases that says, among other things, the Equal Protection Clause demands that racial classifications be subject to the most rigid of scrutiny, meaning the judges, if USDA was going to be allowed to separate individuals on the basis of race, gender, national origin, they would have to follow a process that the Supreme Court has laid out known as strict scrutiny, meaning that the judges would only allow Mr. Vilsack and the claims administrator and the lawyers to isolate and quarantine an individual based on their race, based on their sex, based on their ethnicity, only if there is a compelling governmental interest. As we said, not since 1942, when this government interred or caused Japanese citizens to be interred based on what was then Executive Order, I think it was 9066. This country has taken a position that never again will we treat or subject or allow our citizens to be subjected to discrimination based on those genders. Judges are the guardians of the Constitution. We're saying it's one thing for Mr. Vilsack to allow it. It's one thing for the lawyers to allow it. It's one thing for the claims administrator to allow it. But those judges have jurisdiction over these cases. They should not have allowed it unless, of course, they subjected that process to this doctrine known as strict scrutiny. They did not. As late as 2013, the Supreme Court upheld another case involving the University of Texas at Austin, where a young person by the name of Fisher was being discriminated against on the basis of race, ethnicity, and gender. The Supreme Court renewed its position that says no, the university would have to show a compelling reason. In other words, it has to be more than, well, it's a good thing. It's a good thing to have a bus for black farmers. It's a nice thing to have a school for white farmers. It's a nice thing to have a water fountain for Hispanic farmers. The Supreme Court says no, niceties will never get it. You have to show that there is a compelling reason. And interestingly, no agency has been allowed to segregate, to quarantine individuals based on race, ethnicity, and gender in the last 70 years, going back to that case known as Fred Korematsu versus the United States. No agency has been allowed to do that. Now the question is, why did these judges allow Mr. Vilsack and the lawyers to subject black farmers to that process? We're saying that they violated their oath, and we're asking Congress, the Judiciary Commission, to look into the behavior of those judges for violating that oath. And we're going to be demonstrating outside of the federal courthouse where these judges are on September the 21st, which is a Monday of 2015. Every African American citizen, whether you are a farmer or not, cannot allow a government agency to reorbit, reroute itself, and go back and visit an era, a horrible era that this country says never again will it allow. And Judges Friedman, Judges Sullivan, and Judges Walton, whether their motives were otherwise, but we do know they allowed the government and its subcontractor, IPIC, which is the claim administrator, to discriminate against individuals based on race, gender, and national origin.
Mr. Burrell, earlier, BFAA filed a motion to intervene in the Hispanic and female farmers lawsuit. I have here in my hand a USDA status report dated June 8, 2015. Can you explain to us the ramifications of this document and basically what it says?
Yes. As you said, the Black Farmers and Agriculturalists Association in 2013 filed a motion to intervene in the Hispanic and female farmers voluntary claims process. We filed that motion under what is called Federal Rule of Civil Procedure 24, meaning, and you've heard me give the explanation before, it's almost analogous to we're going on a family reunion vacation and someone, the chairman of the family reunion, is going to call ahead and book some rooms. So we have, before at least a reviewing court, our motion to intervene. However, a couple of months ago, as you noted, June the 8th, the Department of Agriculture filed a USDA status report in the federal courts, giving the breakdown of how the adjudicators, the arbitrators, and the lawyers fared in that process. There were 53,803 individuals in that process. This is not beef amendments now, because I know a lot of people will say, well, have we been turned down? This shows, though, why it was necessary for us to, in fact, intervene. And I think when you look at these numbers, you will see that we were right on target. Of the 53,800 individuals that the claims administrator forwarded documents on to another group known as the arbitrators, these are the judges that will make the decision. Only 6% of those individuals prevail. 6%. That is to say, out of 53,803, I think page 2 shows that 3,210 individuals prevail. Now, is something wrong with a process, ma'am, that will only allow 6% of the individuals? We believe now this is proof positive. This is basically the smoking gun that there's something wrong with this process. And these federal judges, again, are allowing it. There is no way under the Equal Protection Clause of the Constitution where there is a lawful proceedings and only 6% of the people prevail. And you will see, we will do another video where we are actually breaking these numbers down. But here again, most of these individuals were the Hispanic and female farmers who were on the docket, who the claims administrator to allow to go through the process. As we said, that we're going to be in Washington, D.C., September the 21st, outside of the Federal District Court for the District of Columbia, protesting and complaining hopefully that Congress will be able to hold hearings to look into the proceedings and find that there is something grossly wrong. Keep in mind, it was BEFA going before Congress in 2004 and 2005 that allowed us to have the second group of black farmers, in-reef black farmers, admitted. Judge Freeman denied black farmers access to Pickford 1, and Congress overrode his decision. We believe that Congress is going to have to get involved and override again the decisions that have been made by the adjudicators and arbitrators. Join us September the 21st, Monday, 2015 at 10 a.m. in front of the Federal District Court for the District of Columbia. Thank you.